Patent, trademark, or copyright. An introduction to intellectual property or IP. Intellectual property is the property that you own, which may very well be intangible, that you produced, basically by bringing it forth from your mind and creating it in reality. If you've produced something, or if you have a business to protect, you're probably aware that you can get some form of intellectual property protection to prohibit counterfeiters from copying you and profiting from your work. However, I get a lot of calls from small-time inventors and entrepreneurs who are not really quite sure what the differences are between patents and trademarks, or between trademarks and copyrights, for example. So this presentation will walk you through the very basics of what patents, trademarks, and copyrights are and how they're different from each other. Hopefully by the end of this presentation, you'll have a stronger sense of what it is that you need. So as an overview, intellectual property, or IP, falls under two broad categories as I see it. There is the category of creative works, and then there is the purely commercial protection. And under the creative umbrella, there are patents, which protect inventions, and copyrights, which protect basically art. On the commercial side, there is the trademark, or essentially branding. Let's start with the world of patents. Patents come in three forms, depending on what exactly needs to be protected. There are utility patents, design patents, and plant patents. Be aware that prosecuting patents, writing patent applications, is a very specialized area of law that most lawyers are not licensed to do. So in order to get assistance with a patent, you need to work with a licensed patent attorney like myself. So utility, design, and plant are the three kinds of patents. Let's break these down. So the utility patent protects the features of an invention that you have put there in order to serve some useful function. So for example, if you've invented a clock, you could get a utility patent on the gears and springs inside the clock, the mechanics of it. A utility patent is defined by images and or words. There's a written description where you can elaborate as much as you want on what the parts of the invention are and how they interrelate to each other and make the product work. And then there will also be drawings in most cases. And again, you have a lot of license with drawing pretty much whatever you want. You can draw the interior and or exterior of your product. A design patent protects the features of a useful invention that you put there in order to serve an ornamental function. Ornamental essentially means interesting, beautiful, or unique. So for example, if your invention is a clock again, you might be able to get a design patent on the framework of the clock, like you see here in this image. So a design patent is for three-dimensional products like this one, and it's defined pretty much entirely by drawings of the exterior of your product. For the most part, design patents are intended for three-dimensional items. There are some exceptions, but for instance, you could get a design patent for this frame as you see it here, but not for the numbers as they're painted on the face of the clock, because that would be two-dimensional artwork. Also note that even though a design patent is for ornamental parts of the invention, it must actually be a useful invention. So clothing and architecture are eligible for design patents, but something like sculptures are not, because a sculpture serves no useful purpose. It's art for art's sake. And then the third, and definitely the most unusual kind of patent, is the plant patent. You can get a plant patent for a new strain of plant that you have bred by hybridization or artificial selection. I've never had a plant patent client before, but I know that plant patents are blooming these days. as cannabis laws get liberalized. Those are the three kinds of patent. That's it as far as patents go, as far as their categories. There are a few phrases that tend to circulate in popular discourse, like provisional patent, software patent, or business method patent. There's actually no such thing as any of those. There is such a thing as a provisional application for a patent, which essentially just means an incomplete patent application. Software and business methods are both appropriate for utility patents because they serve useful purpose. It just so happens that they're very difficult to register, and therefore they're kind of psychologically in a class of their own, but not legally. Okay, the next type of creative work is the copyright. A copyright is for a creative work that does not serve a useful purpose. It's art for art's sake. So copyrights are appropriate for media that involve words, audio, video, and visual art, like books and movies. And then on the purely commercial side, there's the trademark. A trademark is pretty much what the word suggests. It's a mark for trade. It's basically branding. As you can see on these eggs here, they've been labeled with a mark, the EB mark, which designates where they come from. When you buy eggs, you'd like to know if they come from EB Farms or Lucerne or some other farm. So the legal purpose of the trademark is to designate the origin of goods or services. The mark that you use to brand them does not need to be particularly creative. Trademarks can be used to protect company names, product names, logos, and mascots. Let's take a look at this candy bar, for instance, where you can see a trademark here for the company name, Nestle. That's the name of the corporation that makes this candy bar. And if you look really closely, you can see a little R in a circle here, which means that that trademark has been registered in the United States Trademark Office. Nestle has also registered this trademark, Kit Kat, for the name of this particular candy bar. Of course, Nestle owns many other product name trademarks, like Crunch, for example. And then many packages and products will also have a little tagline down here, like this one, have a break. And if you'll notice, this one is not registered, apparently. And I've put tagline in parentheses here because it's harder to get a trademark for a tagline. So I would like you to focus your trademark budget on your company name and or your product name. Trademarks can also be used for non-textual logos and mascots. Again, these serve to basically designate the origin of goods or services. And some of them are so well known that they don't need words. I'm sure that when you look at this logo or this mascot, you know where they're coming from, what the brand name is. Sorry, Charlie, there is no intellectual property protection for some forms of idea, such as blurbs, trade secrets, and concepts. So let's break down what these three are. These are important because I get a lot of calls for these. These are sort of common misconceptions. I get a lot of calls about people inquiring to get protection on a blurb or a concept, and I have to tell them, unfortunately, that you're not going to be able to protect it. So what are these things? What I mean by a blurb is a word, catchphrase, or sentence for its own sake. So here's an example of a phrase that I coined myself, and when I went online I found that someone else did independently of me too. But that phrase is, I identify as human. So I think that's kind of a cool and catchy phrase, and I would be interested in putting it on t-shirts and sort of influencing people to use this phrase. But unfortunately, it's not something that I would be able to monetize. And the reason is because it doesn't really fall neatly into any of the categories that we've just talked about. It doesn't qualify as a copyright, even though copyrights protect words, but a copyright has to rise to the level of a creative work. And there tends to be about approximately a paragraph rule of thumb In other words, in order to qualify for copyright protection, a written work would have to be really at least a paragraph at a minimum. Anything less than that is it's kind of too likely that different people could come up with the same idea independently of each other. And in fact, that's exactly what happened with this phrase. So I do get a lot of calls from people saying, hey, I thought of this really cool slogan, like "you go get 'em," or something like that. Or they kind of want to start a TikTok. They want to go viral with a cool phrase, basically, and they want to put this phrase on T-shirts and caps, and they feel that it's going to go viral and everybody will be using it, and they want to sort of own that word or that phrase. And unfortunately, I have to tell you that form of protection is not available for just little words and catchphrases like that. The reason it doesn't qualify as a trademark is because there's no underlying good or service. There is no "I identify as human" candy bar. And printing it on a T-shirt does not make the T-shirt an I identify as human T-shirt. That's actually just called an ornamental use of a phrase. It's fairly easy to trademark T-shirts by using your label on the tag, but putting a catchphrase on merchandise basically is not going to be protectable. The next form of unprotectable property, or I should say without a legal instrument behind it, is the trade secret. So a trade secret would essentially be where you have a secret algorithm or formula that you want to make and sell, but you don't want to tell anybody what it is. A secret sauce is the classic example. These days, of course, algorithms are very strongly guarded trade secrets. But the issue is that patents, which would protect formulas and algorithms, are only available to ideas that have been published. So you can't have your cake and eat it too. You can either choose to publish it and patent it, or don't publish it, in which case it's just called a trade secret. But there is no legal instrument for it. There's no such thing as a registered trade secret. And finally, there is what I call the concept. That's kind of a vague term, and people will often say things like you can't patent an idea or you can't patent a concept. It's a little bit of a fuzzy term. So let me clarify exactly what I mean by using this word. So my definition of a concept is an undeveloped idea for the purpose of an invention or the premise of a work of art. So I like this cartoon because it really works for either a patent or a copyright. Let's suppose that this little boy is dreaming about a suit that can make you fly, a flying suit of armor. And he says, wouldn't that be great if I could get a patent on a flying suit of armor? Well, he can't get a patent on just the idea of a suit of armor that makes you fly. That would be an undeveloped idea for the purpose of an invention. It's everybody's dream to get a patent on a broad idea like that and let other people do the work and the engineering, and then kind of force them into paying you royalties for it. Well, it's not going to happen that way. The devil is in the details, and so is the intellectual property protection. Or let's think about this cartoon from the copyright perspective now. So the boy might also be having a dream about a movie about Iron Man. And what he's hoping is that just by having that concept, anytime Marvel Studios makes a movie about Iron Man, they owe him $100 million because it was his idea. He had the idea first. Well, I think it should be obvious to you that just wouldn't be fair, and that Marvel would be entitled to their profits even if they thought of the idea, the premise, after this boy did, because they actually made the movie. Okay, again, the devil is in the details, and so is the protection. Thank you for bearing with me this long. I hope this presentation has been informative. And if you have ideas that you think might qualify for patents, trademarks, or copyrights. Or if you'd simply like to establish a business entity, like maybe incorporate and get a business name licensed and registered, well, I handle that kind of work all the time. I work regularly with individuals and small businesses and nascent small businesses, which are just getting started up. Please see my website at fagerlandlaw.com, which has an appointment calendar where you can sign up for a free consultation. I'm based in Los Angeles, California, but I do 95% of my work online. So even if you're not local, I would certainly welcome a call. So I hope to see you then.